This is our 311th class, and in which we would like to discuss the very doctrine of Ultra Vires. So, this Ultra Vires has combined two words. One is ultra, which means beyond, and virus means power. So, combinedly, it means an act or to act beyond the powers. As the Constitution of India and is supreme, so delegated legislation must not go beyond the scope of the parent act or enabling act if it is found violating the scope, then it would be declared ultra vires and void. Ultra vires is divided into substantive ultra vires and procedural ultra vires. So, substantive ultra vires is the conflict with parent or enabling act, and such can be declared invalid on the following grounds, such as the enabling and parent act is itself unconstitutional. So regarding that, we will discuss the very position of ultra vires in England, United States of America and India. So in England, the parliament is sovereign and therefore it can delegate its lawmaking power to the executive or other agency to any extent. The validity of an act of parliament cannot be challenged in the courts in England. Thus, the functioning of judiciary is to ensure that the administration or executive function conforms with the law made by the parliament. It is to be noted that in England, the validity of an act of parliament cannot be challenged in courts, but the validity of the delegated legislation can be challenged. In United States of America and in India, there is supremacy of the Constitution, and therefore an act passed by the legislature is required to be in conformity with constitutional requirements, and if it is found in violation of the constitutional provisions, the court declares it unconstitutional and void if the enabling or parent act providing for delegated violates the limits of the Constitution, it will be declared unconstitutional and void, and subordinate or delegated legislation made under the said act will also be declared to be unconstitutional and therefore void. The limit of the Constitution may be expressed or implied, and in that connection, we would like to discuss certain constitutional provisions of Indian Constitution, such as Article 13, Clause 1, Clause 2, and Clause 3 in relation to Part 3 of the Constitution, which consists the fundamental rights. So also Article 245, 246, 248, and 254 of the Constitution. So Article 13(1), which provides that all laws which are in force before the commencement of the Constitution, insofar as they are inconsistent with the provisions of Part 3, that is, the fundamental rights, shall to that extent of the contravention would be declared as void. So Article 13, Clause 2, the state shall not make any law which takes away or abridges the rights confirmed by Part 3, and that is fundamental rights, and any law made in contravention of this clause to that extent of contravention would be declared void. And clause 3 of Article 13 makes it clear that for this purpose, under the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, customs or usages having in the territory of India as force of law. So the legislature thus cannot violate the provisions of Part 3 of the Constitution guaranteeing the fundamental rights if the parent or enabling act is violative of the fundamental rights, then such parent or enabling act will be declared by the court as unconstitutional and void. So also the very subordinate or delegated legislation made under the parent or enabling act will also be held to be unconstitutional and void. So now we'll go to Article 245, which makes it clear that the legislative power of Parliament and of the state legislature are subject to the provisions of the Constitution. So Parliament may make laws for the whole or any part of the territory of the state, and the legislature of a state may make laws for the whole or any part of that particular state. So, in that connection, we would like to discuss the I.Cauvery Water Dispute Tribunal Ordinance of Karnataka government, which was declared as void and unconstitutional by the Supreme Court, where it was held as extraterritorial operation, as because the very state has the power to make law regarding the whole or any part of that territory. So the Supreme Court held it as extraterritorial jurisdiction, and in violation of this very provision of the Constitution under Article 245 on the ground of extraterritorial operation, the Supreme Court held it as unconstitutional and void. And regarding Article 246, which makes the provision in respect to the distribution of power between the union and the state under three different lists, such as union list, state list, and concurrent list. So the Parliament has the power to make laws under those items which are specified in the union list. So also the state has the power to legislate on those items which are specified under state list, and regarding concurrent list, both the union and state has power to make laws. But if there would be any conflict in between the laws enacted by the union and by a state on the same subject, then the very enactment or law made by Parliament will supersede the very legislation or act made by a state. So also, under Article 254, once the President has given assent to any bill enacted by the state legislature, then it would be effective as law. And regarding Article 248, which provide residuary power which has been vested into the Parliament of India. So, after analyzing this, we found that if the enabling or parent act violates the implied limit of the Constitution, it will be declared as unconstitutional and it will be void. So the delegated legislation made under the act will also be unconstitutional and void, as it was decided in Indian Oil Corporation versus Municipal Corporation in 1993 by the Supreme Court. So, in our next video, we would like to discuss regarding the second ground that violates the very provision of the Constitution and would be declared such parent or enabling act as unconstitutional, void. So those acts made or rules, regulations made under delegated legislation